given in the page number 74, Mark. Two.
10th of September. List again on 10th of September. You are for the petitioner. You are for the petitioner.
Yes, Lord. Indeed.
Yes.
But the pleadings are complete in this matter. However, there are two things that I wanted to point out, if my Lord would permit. In this matter, my Lord, about a week ago, and we had moved it for the this comes today, my Lord. The only difficulty is, my Lord, this matter I will take at least 1.5 hours to argue, my Lord.
There's some audio issue. Your voice is breaking at times.
Is it better now, my Lord?
Yes.
My Lord, I'm saying we had moved a memo for mentioning on last week to have this matter listed, and we had moved it for 3rd of September, my Lord. Somehow, my Lord, the matter has come up today, and the only request is this, my Lord, because I'll take about 1.5 hours. It's for final arguments now, my Lord. If my Lord can have it on some very short date, if possible, 4th of September, I would want to physically argue it, my Lord. That's number one. That's my first difficulty, my Lord, because all arrangements were done for 3rd, my Lord. But, I mean, if still my Lord would want to hear, I have no problem. The second thing is also this, my Lord. There was one application for impediment that we had filed, my Lord. Some of the similarly placed applicants had to be impeded. Last time it was not on record. It is on record today, my Lord. IA 2359 of 25.
Yes.
So, my Lord, these are similarly placed applicants as the petitioners, my Lord. If my Lord would be kind enough to have it only on 4th, I will physically come and argue, my Lord, and this memo of parties will also be filed by tomorrow so that the matter is ripe for final arguments, my Lord. Last occasion, the state took time. We do not oppose, my Lord, in all fairness. If 3 days accommodation can be granted, my Lord, it just I'll be in a better position to assist my Lords.
What is the issue involved
The
here?
issue is this, my Lord. We are all contesting for government teachers, my Lord, as per an advertisement of the state government. Thereafter, there was some ineligibility that came in because of a Supreme Court judgment, which was misread by the learned state. Then there were some applications and review petitions filed before the Honorable Supreme Court, in which the Supreme Court clarified that we, the petitioners, are eligible to take part in the process for teachers' recruitment. We are all diploma holders from an institute called Nios. The Honorable Supreme Court then clarified in December 24 that all of us are eligible. The benefit of that order was given to all across the state, because it was a confusion across the country. So all states have given similar benefits to petitioners like us. After the Supreme Court order, my Lord, where Supreme Court laid down 2 conditions: one, that we had to be in service as a these 2 conditions were fulfilled, then we are eligible to participate in the ongoing process for government teachers. Now, the Honorable Supreme Court did not lay down that what should be the mechanism of verifying whether we were in service or not. Thereafter, my Lord, a writ petition before this Honorable Court was allowed in terms of the Supreme Court order. Immediately thereafter, the government has released a circular. The subject matter of the present writ petition is this circular. The circular, my Lord, will find at page 54. This circular is impugned, my Lord, in this writ petition, wherein some additional documents, my Lord, which were not required from day one, had been sought by the government, my Lord, without any basis of power or authority in any provision of law, my Lord. So therefore, all that we are challenging in this writ petition is that at page 54, they have asked me for 8 documents. None of these documents, my Lord, were required at a previous time. None of these documents the Honorable Supreme Court lays down. None of the documents the NCT lays down, which is the rightful authority, my Lord. And admittedly, my Lord, but state has stated in their counter, there is no source of power to ask for these 8 documents. So all that I would want to assist my Lords with is that why should these 8 documents be called for? Specifically, when similarly placed applicants like me, we have been recruited in 2019, 2021 also, and none of these documents were ever called for. Similarly placed candidates like me have also been recruited 2 months back as per the state ODL system. These documents have not been called for. And I will show from the records, my Lord, that these documents were not required in 2017. My enrollment for the course was as per 2017 notification of the Government of India. the government of India had put the onus on the government to verify whether I was in service or not. I will show my lord each and every document. So after that 8 years, my lord, in 2017, when the onus was put on the government, today the government falling back and saying that please give me those 8 documents is completely arbitrary, is my case. Plus, there is no source of power to it. And the third aspect is, my lord, because 8 states, I say this with responsibility, because I had the occasion to assist honorable different high courts as well as the honorable Supreme Court in the very same matter. 8 states have implemented the Supreme Court's order without asking for these documents. That is very, very important, because it was a central government notification, central government scheme applicable across all states across the country. All the states except the present one, my lord, have implemented this without asking for these 8 documents. So therefore, what I'm trying to say is, my lord, that whether the state can ask for these additional 7 documents, which were never from 2017 till today in picture in any manner whatsoever. In addition to that, as I said, the state in the counter has not justified the source of power. That what power do they have to ask for these 7 documents? And I fairly
All right,
squarely,
all right.
I'm sorry, my lord.
All right, Mr. Sahayak, what do you say? We'll have it on a hearing
Very
date.
simple. It is a very short issue. This notification which they have challenged was issued on 17th June. And if it is pleased to see the judgment, only one paragraph, page 624.
No, Mr. Sahayak, what I'm saying is that the Learned Counsel on VCS says that he would like to argue physically in a physical
Very
mode.
nice.
So let us have it on Thursday on a hearing date.
Lordship may only do one thing. I am game for that.
Hmm.
If Lordship is pleased to take the order dated, this was the interim order which was passed.
30th June was the first order, and then it was extended, my lord, on 30th of July.
2025.
25, yes.
Here, Lordship will kindly come to paragraph 11. Upon considering the submission made by the learned counsels for both sides and considering the entire facts and circumstances of the case, it is seen that as per the order of the Honorable Supreme Court passed in the case of so-and-so, the qualification obtained from NIOS shall be treated as valid for all intent and purpose, provided the candidate was in service on 10/8/2017 and having 18 months DLE from NIOS. But from the notification which is under challenge, it is seen that as many as 6 numbers of documents were asked from the candidate for verification, along with 18 months DLE certificates and mark sheets to NIOS of the applicant completed on 1/4/2019. Thus, from the notification, it is seen that those some list of testimonies documents were sought from the candidate, but it cannot be held that there was any apprehension that the cancellation of candidature of the present petitioner. Further, the completion of verification also may take some time, as submitted by the Learned Counsel, Education Department. Thus, at this case, this court is of the opinion that there is no necessity of suspending the impugn notification dated 17/6/2025 issued by the Director of Elementary Education. However, results of verification may be kept in abeyance till returnable date. So we have completed the verification now, and we are very soon we are completing the recruitment process also, subject to clearance from this honorable court. There are 137 writ petitioners, and they are also filing some implement. 32 that Lordship has not considered till now. So
As implement as new petitioners.
new petitioners, the total 137 plus
32.
38. So what will be the total today? About 169. So by keeping 169 posts vacant, let Lordship give us the clearance to go ahead, because their rights will be protected, and they can argue the matter on Thursday. Because we want to continue with the process, and there is an attempt on some vested interest to derail the process of recruitment. There are about 5,000 posts.
What is the figure?
169.
169.
Their interest is protected. So I don't think they have any further demands. So let us go ahead with the rest of the 5,000 candidates.
But we're talking about Thursday. Today is
Thursday,
Monday.
Lordship. On Thursday, I'll argue. No difficulty on that. Let us go ahead, Lordship,
No,
because I know what can happen on Thursday also. I can foresee,
that could be done also, but why segregate at this stage?
Lordship.
Why
Because I'm
segregate
giving my
at this-
undertaking. It's my personal undertaking that Thursday I will be available to argue, my lords, without any excuse. In fact, after this, the matter also came up on 30th July, where the
Lordship,
government sought time.
as first item on Thursday. no?
Very well, absolutely no
No.
problem.
If something happens on Thursday, then we'll see that 169 was not filled up, you go ahead.
Difficult. I have made my position clear.
Because if matter can be taken up on Thursday,
Yes, yes.
then why segregate, give
Only
some
thing is
post?
that,
Go ahead
because
with some
these
post.
137 candidates, why rest of the recruitment process should not go ahead? Because we have completed the verification. We have to streamline the select list now. And we want to we want to give the appointment in next 15-20 days. The teacher students are suffering.
So just have the 30th July order, my lord. On 30th July, after the returnable date, it was the government which sought time, which we deadly did not oppose, my lord. And in fact, we were in a hurry. But with all due respect, my lord, I understand, I appreciate the activeness that is being shown by the government. And I'm assuring, my lord, it's my personal assurance that Thursday, first item also no problem. Plus, my lords, we are 139 plus 32. So if on Thursday, my lord can take a call instead of considering the matter today. And my lords may call for the reports. We had moved it for 3rd September. Somehow it has gotten listed today, my lord. So therefore, there's a genuine difficulty. And I'm not based out of Guwahati, my lord, or else I would have been there physically present. My lord. So all the times, I'm not even asking for a week, my lord, just 2 days, my lord. My lord, may have it as the first item, absolutely no problem. I'll ensure that we are present, my lord.
If they are successful, their position is remain intact. Their interest is protected. What I am submitting, I am conceding that we will not touch 169 number of posts.
No, it's not one. No, the question is, what is the
And how much
what-
time they want to take, there is no difficulty.
No, what is the difference in 30th July and today? Please see the 30th July order. See the last order. The government had sought time. So I am just saying that whatever is being submitted by the learned AG, with all due respect to that, from 2 orders, whatever the position has been, for the next 2 days it can be maintained. And on that day, my lords may take a call. I will argue the matter finally.
Okay, so
And-
fix it then, Thursday.
Very well, my lord. But the interim order,
That is my submission.
no, the IA may be allowed for implement, my lord, so that we can file the memo.
Subject to lordship's convenience.
IA, let us see.
Plus
Any
2,
objection to the IA?
For implement.
Yes.
No.
Okay.
2359 or 25, my lord. Whereas 7 we have stated, my lord, they are similarly placed.
How many applicants are here?
My lords, in the IA there are 32.
32.
In the original matter, they are 139.
What is your good name?
My name is Mandeep Kalra, my lord.
I heard
Kalra.
Mr. Mandeep Kalra, Learned Counsel for the applicant through RVC, who submits that by filing this application, the applicants seek impletement of additional impletement of the 32 applicants as
Petitioner.
petitioner numbers
140, my lord, 140 onwards.
142,
171.
171. Since they are also similarly situated and the outcome of the writ petition would have a bearing on the interest. First of the Learned Counsel submits that by impleting the applicants, the same would not change the nature and character of the writ petition, main writ petition. To stop. Next para, Mr. D. Sahayak, Learned Advocate General, Assam, appearing for the state, clearly submits that he has no objection if the IA is allowed. In view of above, the application stands allowed as paid for. Then what about your implement? Your cost title?
So by tomorrow we'll do it, my lord, 100%.
Okay.
The amended memo parties will be filed by tomorrow. The cost title amendment will be done by tomorrow, first half, my lord, without fail.
What about this IA 2555? What is this? You're for implement as petitioner. As what? Respondent. As respondent. So how will your right be affected?
If this IA, we may have some objections. If my lord would want to consider, my lord may issue notice. We'll file a reply if my lord would want to consider. But as an officer of the court, I feel their right is not impacted in any manner.
Is precisely the reason why I said modification of the interim order. There will be some ploy from either side, you don't know, which will delay the whole process.
I'm sorry, my lord. It meant
I am easily saying that no objection from our side. Now, one side is saying that there is objection regarding.
no, Manoj, I don't know. These people are not similarly placed as the applicants. If they want to implead as a respondent,
So that
I
is
don't
why
know how is.
keeping their interest intact, lordship, they modify the order, then.
No, I'm sorry, my
whatever
lord.
They want to
Please
file
don't put.
objection, further objection, I have no option.
My lord may consider on the next day whether they're important. In my opinion, they're not important in any manner because they're not similarly placed as me. If they're agreed, they can file an individual writ petition. And I am not nowhere connected with them in any manner, my lord, whatsoever. I'm sorry, the learned lady should not put it on the petitioners for any reason, my lord. That's not, we are not connected to them in any manner whatsoever.
This is a bit different, isn't it? Applications for implement as respondents. Isn't
And
it?
this concept is unheard of, my lord. Why would private parties want to implead as respondents in a writ petition?
You could very well file a separate writ petition. Why do you want to be pleaded as respondent? So let it be pending. Will not issue anything. In view of the order passed today in IAC number
2355. 2359, sorry. 2359 or 25.
2359 of 2025, the petitioners shall file the amended course title
By
in
tomorrow.
2 sets within 2 days. Full stop. As agreed to by the learned counsels for the rival parties, list this matter for admission hearing on 4th of September.
This is one short request, my lord.
Yes.
The interim order may continue till the next date. Twice it has been continued, my lord. Hopefully for the last time it may be continued.
As the first item in the admission call. Interim order passed shall continue till that next date of listing.
Highly object.
I'm so deeply grateful, my lords. Deeply grateful.